All right, let's get right into it. What we've got here is a story that honestly feels like a David versus Goliath movie script. You have one homeowner going up against some of the heaviest hitters in the financial industry. And let me tell you, this is about way more than just one house. It's about an entire system that's being put on trial. So, the core of what we're breaking down here is this incredibly powerful conflict. On one side, you've got a single homeowner out in Idaho. And on the other, two venture capital firms backed by a whole network of lawyers and financial groups. The prize might seem small, a single family home, but the stakes, well, they're absolutely massive. So let's set the scene. Our story kicks off with what should have been a standard foreclosure in Idaho. But as you'll see, it was anything but. This thing spiraled into a federal case that's now raising some really serious questions about fairness, potential fraud, and, frankly, the rule of law itself. Now, to really wrap your head around what's happening, you gotta know who's who in this whole drama. First up, you have Jeremy Bass. He's our homeowner. Then there's Carrington Mortgage Services. They're the ones managing the loan. The buyers of the house, that's two venture capital firms, DPW Enterprises and Mountain Prime. And they've got their lawyers, a firm called HWM, plus the trustee who actually conducted the sale, IDA Law Group. Now, I know it's a lot to keep track of, but trust me, you're going to want to remember these names because how they all fit together, well, that's the real crux of the story.
And that really brings us to the billion-dollar question that's driving this whole thing. Was this just a normal, run-of-the-mill foreclosure done by the book? Or was something else entirely going on behind the curtain? The homeowner, Jeremy Bass, alleges that it was a rigged game from the very beginning. Let's dig in and see why.
So the first red flags, they actually pop up way before the auction ever happens. You see them in the documents themselves. A foreclosure is only as solid as the paper it's printed on, right? So what exactly did that paper trail look like? Okay, this timeline really shows you how things went off the rails. So in 2017, Carrington takes over the loan, pretty standard stuff. But then fast forward to late 2019, and things get really weird. Bass gets a whole new loan packet in the mail, but get this, it's backdated by over 7 years. Then he claims he was offered $100 to just sign these strange documents. And it doesn't stop there. He then alleges that a second deed of trust just appeared out of nowhere, effectively doubling his debt. He says he never consented to it. And right here, this is the smoking gun for the fraud allegation. On the left, that's Bass's real, verified signature. On the right, that's the signature from the document in question. Now, it's important to know, Bass actually has a background in document verification. So he immediately saw problems, especially with how the letter B was formed. For him, this wasn't some tiny little mistake. He believed it was a straight-up forgery. And look, this stuff isn't happening in a vacuum. A financial historian, Dr. Jonathan Reynolds, points out that these kinds of allegations, funky paperwork, possible forgeries, sound an awful lot like the whole robo-signing scandal that absolutely rocked the mortgage industry after the 2008 financial crisis. It's a pattern, a kind of chaos that has a long and very ugly history. So all of this messy, questionable paperwork, it all builds to this one single critical moment, the foreclosure auction. And this is where those allegations of a rigged game really come into sharp, undeniable focus. Before we talk about what went wrong, let's talk about how it's supposed to work. In Idaho, there's this really important legal case called Breckenridge that basically sets the rules. A bidder who's on the level shows up with a certified check for more than they think they'll need to pay. Why? To cover any possible winning bid. They win, and then they get the difference back as a refund. It's simple, and it proves they were ready for a real competitive auction. Okay, and this is where it gets just wild. It perfectly lays out the whole problem. Look at the two bidders. A fair bidder, like in the Breckenridge case, brings a big check ready for anything. But then you look at the bidder in Bass's auction. They brought a check that was pre-printed for the exact winning amount, down to the last cent. I mean, come on. The question just screams at you. How in the world could they know the final price unless the whole thing was a setup from the very beginning? It gets worse. The buyers later admitted in a court filing that, yeah, they did contact the trustee before the auction to talk about the opening bid. To Jeremy Bass, this wasn't just some casual chat. He called it a felony admission, an admission of bid rigging and collusion, which is a massive violation of the Sherman Antitrust Act. That's the federal law designed to stop exactly this sort of thing. So, you are probably thinking, with all this evidence, this has got to be a slam dunk in court, right?
Well, the fight was really just getting started. Bass quickly learned he wasn't just up against the other side's lawyers. He was fighting the very rules of the legal system itself.
Bass was representing himself, and he walked right into what some legal experts call a temporal trap. See, the other side filed a brief with totally new arguments just 4 days before the hearing. Bass scrambled, working all weekend to file his response the day before. But when he got to the hearing, the judge just shut it down, saying there's, and I quote, no provision for there to be a reply to a reply. Just like that, his evidence was thrown out. This whole situation created what Dr. Robert Chen, a legal systems analyst, calls a recursive barrier. It's this frustrating loop. The court refused to look at his evidence because it was technically filed at the wrong time. But then later on, the court used his failure to provide that same evidence as a reason to rule against him. It's a procedural catch-22 that meant the actual facts of his case never even got a proper look. And there's another tactic you need to know about here, something called strategic mooting. Basically, it's when one side rushes to do something irreversible, like, say, an eviction, while the other side's appeal is still waiting to be heard. The whole point is to make the court say, well, it's already done. Nothing we can do now. It's a way to kill an appeal before it even gets off the ground. And that is precisely what happened in this case. I mean, the irony here is just brutal. While Jeremy Bass was literally inside the courthouse, filing emergency papers to stop the eviction and protect his rights, the eviction was already happening at his house. The very system he was turning to for help was being outrun by the events he was trying to prevent. Okay, so here's the most important takeaway. This is not just a story about one guy in Idaho. Not at all. This is a story that cracks open a window into a huge national system, and it brings up some really deep, profound questions about justice in America today. Hey, remember that cast of characters from the beginning? Well, here's where you see how they're all connected. These law firms, the loan servicers, the trustees, they're all part of the same professional groups. They sponsor the same industry events. They even represent each other in different court cases. Critics have a name for this, the foreclosure machine. It's this tangled web of relationships that's so tight, it makes you seriously question if anyone can truly be impartial. And that tangled web? It had a very real impact on Jeremy Bass. He spent 2 years trying to find a lawyer to take his case. But over and over again, he was told there was a conflict of interest because so many local law firms already had business relationships with these big national players. You know how many lawyers he found to help him? 0. None. He was forced to represent himself, not because he wanted to, but because the system gave him no other choice. This whole mess just forces us to ask a really tough question, and it's summed up perfectly by this judicial ethics researcher. If a big company with a team of lawyers can introduce new evidence at the last minute, and a regular person representing themselves is blocked by procedure from even responding to it, can we really say that our system offers meaningful protection for something as fundamental as property rights? And that's really the question that hangs in the air after all of this, isn't it? This whole story, it kind of shakes your faith in the system. When you've got one person, no matter how smart or determined they are, facing off against this massive, coordinated, and incredibly well-funded machine, you just have to wonder, are the rules of the game actually designed to be fair and find the truth? Or are the rules themselves just part of the game?